Okay, good evening everyone, and welcome back to the online seminars on Wednesday. Tonight we are joined by Conor Ahern, consultant solicitor for Florian Exash, who is going to be revisiting his QS and construction law, the interaction with updates and information where appropriate. So as always, we are recording this, and if you have any questions for Conor, please use the Q&A panel at the bottom of your screen and he will endeavour to answer all of your queries at the end. And as always, if you have something specific you wanted to ask Conor about, his email details will be on the presentation slides, but for reference, it's conor@silverllp.com. Please feel free to email him. He is quite friendly and is happy to answer. So without any further ado, Conor, over to you.
Okay, thank you very much, Julie. Good evening, everyone. Yeah, you're all welcome to this topic. It was actually the first webinar that I ever did, and basically what it is, we're looking at the interaction between quantity surveying and construction law. So yeah, just a couple of points that I thought were of interest during, I guess, my training contract, which has thankfully now come to an end, and just some points that I wish I knew when I was, when I was practicing as a QS in industry. So, look, I hope you find the points of interest and you can, take them forward and apply them to what you're doing on a daily basis. Right, so that's a bit on me. That's my profile. I'm a consultant solicitor. Previously QS for 12 years, as I said. So, yeah, look, there's, if anybody is interested in talking more about this as an option. It seems to be, a lot of people reaching out lately to ask about the route. So look, that's it, kind of at high level. If you want to get more detail on that, just feel free to get in touch. Okay. Right. Moving on. So the agenda this evening, we're looking at. The first one is just a bit on lump sum and remeasurement contracts. So just a bit of procurement stuff. Then we're going to look at the measurement rules, SMM7 and NRM3. We're still in a bit of a period of transition with those, so we'll talk about them. Payment schedules following the case of Roe versus Balfour Beatty. We'll also look at payment notices and payless notices and what the position is now following Roe versus SMT, before we finally wrap up with the current position on smash and grab adjudications, and in particular the position on true value adjudications as well. Okay, so look, we'll get stuck into the lump sum remeasurement stuff. So first up here we have the standard billing contract 2016 with Quant. So look, I use the JCT forms as in my experience they are the most they're best known in industry. And look at for these slides you're just trying to get an idea of the principles, and they will apply to obviously other forms of NEC and FIDIC and plenty of other types of standard forms. But look, this pretty much does focus on JCT. So first point here is that this is a remeasurement contract. If you look at the wording in there, it says that the work is set out in bills of quants which are prepared by the employer, and they are prepared in accordance with the measurement rules. Now, if there is an error in the employer's requirements, including the production of the bill of quants, for example, an unstated departure, erroneous quantity or description, well then that must be corrected and the contractor will be entitled to a variation. Errors in the contractor's proposals or in the CDP analysis are to be corrected but shall not be treated as a variation as well. So you can see there where the work has been, where the bills have been prepared by the employer, under the standard form, the employer retains the responsibility for those quants. If there is a difference, then the contractor is entitled to the variation. I mean, that would just typically be an add and omit type situation, where you could basically omit the bill quant and then add back in the actual quantity once you've got around to remeasuring the construction issue drawings. My final point here is that this position is commonly altered through schedule of amendments. Just to say, if you have a standard billing contract with quants, doesn't automatically mean it is remeasurable. You got to check the where you have a schedule of amendments. You got to check where the if that position has been altered, and if it is, it'll usually be in around section 213, 214. So so do be aware of that. It's a very important point to bear in mind, and to understand your position from the get-go on your contracts. Okay, then I mean, just you know, the standard building contract here, we had the with quants. I mean, we obviously have the without quants version as well. You know, the without quants obviously means that you know, there are quantities included, but basically the without quants form traditionally means that it is a lump sum type contract. So that's where, you know, most of the time where you have employers that you know, they call the contractor before entering into contract saying, look, you know, we want to make this a lump sum contract. In, you know, in that situation, traditionally they will use a without quants position, and the contractor will have to check the quants pretty quickly in order to secure the work, which does happen, and traditionally the parties will go forward with the, you know, on the without quants basis there. But again, that can all be changed through the schedule of amendments, so do bear in mind the importance of those documents as well. Right, moving on to the standard building contract with approximate quants. Now, this is frequently used for larger works which are designed by the employer, and the employer provides drawings and approximate quants to the contractor for pricing. Now, again, the position is the same as the standard building contract with quants, insofar as if there are errors in the ERs, for example, drawings, specs, schedules, which are not dealt with in the contractor's proposals, again, that is treated as a variation. Errors in the CPs, the contractor's proposals, again, for example, erroneous quants, rates, drawings, emissions, well, then again, these again are not treated as variations. So you can see, you know, where the contractor does take on the responsibility of the CDPs from an early stage. Very important that he understands that, because you know, just again, just assuming that you have an approximate quants contract, you know, does not automatically mean that everything is remeasurable, and definitely any of the CDPs will not be. Again, final point here is that, again, commonly altered through the schedule of amendments. You know, so a very important document that needs to be reviewed and given careful consideration. So, you know, it is a remeasurement contract. So the point here, all work is remeasured prior to certification, and the contractor is paid based on actual quantities of work carried out. So again, each month basically you're having to sit down and carry out the remeasurement exercise, because that's the basis upon which the contractor is going to get paid. So again, just very important tool. It's a bit more admin heavy. I mean, you know, that's more difficult to say than traditional lump sum, where, you know, you have a fixed quantity in the bill and you get paid based on a percentage complete. That's obviously a lot easier to administer. So, you know, these remeasurement contracts do take a bit more. There is a bit more involvement. The final point here is that there is a difficulty with approximate quants, where quants are not a reasonably accurate forecast of the work required. And this can result in contract rates being adjusted and a fair allowance for such difference in quantity to be made under clause 5615. So that's basically where, you know, as it says, your contract quantity is not a reasonably accurate forecast. I mean, it's actually, I mean, that's, you know, whether it is reasonably accurate or not kind of depends on the facts and the circumstances. I mean, there's no kind of set rule, but it would come down to, you know, usually a percentage basis of how far out the you know, the quantity was. Because obviously if you know, if it is significant, then, you know, the contractor may be entitled to, you know, an increase on the basis of, I don't know, additional plant, additional labor, additional materials, whatever the case may be, you know, which he could not reasonably have foreseen when he had been given the quantities as prepared by the employer. So look, that's just a bit of background into those standard forms, a bit of procurement stuff to start us off with. We'll conclude now, and we're going to move forward into the next section, which is the measurement rules. So the JCT 2016 suite of contracts has amended the measurement rules from SMM7 to the new rules of measurement. You know, if you read the definitions in your 2016 contracts, the measurement rules will be incorporated in there in section 1, and they are confirmed as follows. The measurement rules are the RICS new rules of measurement, detailed measurement for building works, in the form published at the base date, unless otherwise stated in the contract bills. so it's it's new, well, relatively new. I mean, the 2016 form, I mean, that shouldn't really be new now, but yeah, it is certainly a change from the 2011 version, and pretty much all JCT versions before that would have referred in some way, shape, or form to the standard method of measurement. So it's a change. Again, just understand how it's incorporated. It's incorporated through the definition in section 1 of your contract. So it doesn't stop you changing that again if you are minded to do. It can be changed through the schedule, through a schedule of amendments. So yeah, you can put in whatever you want. I mean, but do be aware that the standard position on JCT is currently under the 2016 versions is NRM7. Okay, so new rules of measurement. So just an overview here. There's 3 sections. So the NRM1, this looks at guidance on the quantification of building works and to prepare cost estimates and cost plans. It's seen as the cornerstone of good cost management on construction projects, which enables more effective and accurate cost advice to be given to clients and other project team members, as well as facilitating better cost control. Very much focus on a historic cost database for future estimating purposes. NRM2 is mainly written for the prep of bills and quantified schedules of works, although the rules will be invaluable for designing and developing standard or bespoke schedules of rates. So again, it is about having this database, and predominantly has an estimating based focus. NRM3 then gives guidance on the quantification and description of maintenance works for the purpose of preparing initial order of cost estimates. The rules also aid the procurement and cost control of maintenance works. Again, it's written, it's very much written focused on estimating. One of the criticisms that that has been used of NRM is that you could be in a position where quantity surveyors know the price of everything, but potentially the value of nothing. So it's all about knowing the price, knowing what your base cost is. I mean, that's definitely with a view to giving more accurate advice to clients up front, which is as I said here, the aim of NRM is to have more transparent pricing information. Again, it just promotes a better understanding of pricing for clients and contractors in order to have their database of historic cost information. Now, in my experience, and I'm sure in the experience of many of you guys as well, is that the use of bill of quantities has seriously fallen out of fashion in recent years. The rise of design and build has certainly impacted this, and employers and contractors alike have certainly embraced the design and build approach. Employers favour the flexibility of specifications and drawings rather than the straitjacket of a bill of quantities, whilst contractors favour the design and build approach due to pricing strategy and due to the ability to allow contingencies in various aspects of the works, which otherwise would probably get would be highlighted if the traditional bill of quantities was prepared and it was much easier for the employer or the employer's QS to be able to line the bids up side by side and to be able to see where each of the contractors were high or low. So again, we talk about the new rules of measurement. A lot of it, I mean, a lot of it is based on that database, but yeah, it's how much application it really has seems to be limited because of this DMB approach. And I mean, certainly a lot of contractors and employers out there are favoring the just the builder's quants approach. So that is another aspect of the measurement rules that that has to be taken into account. But look, we're going to wrap up this section, and yeah, look, it's just understanding how the measurement rules are incorporated, understanding that you can change them if you want to. There's no issue with that, and can be done through, again, a schedule of amendments. And yeah, that's pretty much it for measurement rules. So we're now going to move on and get into the more case law type stuff. And on that basis, we're going to start with payment schedules. So in 2016, there was a very important case in relation to payment schedules, that is Grove versus Balfour Beatty. Now, the background to this case was that Grover, property developer, and employed Balfour Beatty to design and build a hotel. Now, the parties had agreed a payment schedule for payments up to the contract completion date. Now, the contract completion date was agreed as July 2015, and that was as much as the payment schedule in the contract allowed for. So obviously, what happened was the works were delayed, as we all know frequently happens, and continued beyond the contract completion date. Obviously, Balfour continued to work on site, and they submitted an interim valuation for work carried out in August 2015. Now, at the time, the relationship was quite strained, and Grove basically wrote back. Grove valued the work carried out by Balfour Beatty, but what they did was they basically said no payment is due, because the payment schedule has expired, and they weren't of the mindset to update the payment schedule, given the relationship that was in place at the time. Now, they ended up the case ended up before the TCC, and this was what the outcome. What the outcome was. So the courts decided that it was deemed reasonably foreseeable that the omission of any such provision could have a commercially disadvantageous impact, and the courts would not interfere with a bad bargain. Interim payments for any work under a construction contract did not mean a party was entitled to interim payments for every single piece of work under that contract. Entitlement could only be realised at the agreed intervals specified in that contract. So the next payment due to Balfour that was the final account, as under the contract, that was when the next payment was. So you can see the problem was when the payment schedule expired, there was basically no mechanism in the contract that catered for payments between the expiry of the payment schedule and the final account. Now, the parties continued to value the works and carried on the usual valuation process, but what Grove did was they held the money that was due under those payments, and were going to and used it and paid the contractor once he had actually achieved practical completion, or completed, issued his final account, and it had been properly assessed. So just a word of warning here is that beware of the payment schedule, because it is a very important document, and if you are signing up to a payment schedule, make sure that you give yourself plenty of run-off time to allow for delays, which we all know regularly occur in construction contracts. The other way is, is to complete the interim application section in the contract particulars at clause 4.8. Now, that is frequently done and should be noted as the 28th day of each month, which will basically begin on the month when the contractor starts on site. Now, the reason why we say the 28th of the month is obviously because, we only have 28 days in February. So if we put in the 30th of the month, but then on a strict interpretation, which is what the courts applied here in Grove versus Balfour Beatty, then you could be in a situation where the contractor is not entitled to any payment, for work done in the month of February, and will have to wait for that payment to come along with March's money effectively. So, just a word of warning: be careful with it. It might sound harsh, but the courts, the English courts traditionally do not interfere with a bad bargain, and that's what they saw this agreement as, and unfortunately was in Balfour Beatty's, or went against Balfour Beatty effectively. It's harsh, but another aspect to this was that did the scheme come in to basically satisfy any incomplete parts of the payment mechanism, and they decided no, not in relation to the payment schedule. It will come in relation to establishing your interim valuation date, due date, payment, payless notice date, and final date for payment, but not in relation to the payment schedule itself. So look, just a word of warning, and bear it in mind the next time you see a payment schedule being proposed under your contract. It's always worth asking for an extension on that, because you never know, you just don't want to end up in the situation that Balfour Beatty were in on this project. Okay. So look, we're going to move on to Payless notices. Obviously, we're all very familiar with those. Well, payment and Payless notices, but obviously, I mean, I was a QS for 12 years. I can't remember many payment notices being issued. It was, traditionally the Payless notice. And two key elements that are required in a Payless notice is which is identified in the Housing Grants Act, that's section 110A. So the first element is you need to provide a base of calculation for your Payless notice, and you also need to state the sum which the employer considers to be due. If you have those two elements in your Payless notice, then generally it will be found to be valid. So what happens if there is an error in the Payless notice? Now, I had this experience in the past where I had a wrong date on the Payless notice, and I had an uncomfortable conversation with my opposite QS, and he was saying that therefore it had to be invalid. And look, obviously it caused a bit of panic at the time, but when we went away and did the research, obviously, it wouldn't come down to such trivial events. But look, I wish I had known the position that we're going to come on to here in Grove versus S&T, and you'll see the need for, it's a matter of fact and degree when we're looking at whether a Payless notice is deficient or not. But just a word of warning, if anyone ever claims that your Payless notice is invalid as a result of an incorrect date, okay? Word of warning there. Right, so Grove versus S&T, now not to be confused with the earlier case of Grove versus Balfour Beatty. So this case, in 2015, Grove engaged S&T to design and build a new Premier Inn out of Heathrow. The contract incorporated JCT Design and Build Contract 2011, and the works were due to complete in October 16. But unfortunately, again, we had some delays, and PC was achieved in March 17. So you had like a 6-month delay there, 5-6 month delay. So shortly after PC was achieved, but before the works had been certified, S&T sent Grove its interim application 22 and claiming payment in the sum of over 14 million. Grove responded with its payment notice, which valued the works at 1.4 million. Then shortly after, Grove issued a Payless notice, deducting LADs, and the total sum due was 0. Now, S&T maintained that Grove's Payless notice was non-compliant on the basis that Grove had not attached a spreadsheet, which included the basis of calculation information. But bear in mind that Grove had previously provided the same spreadsheet under a previous Payless notice, and the calculation had remained unchanged in application number 22. So you can see S&T's case is that one of the numbers that form part of the Payless notice didn't have the basis of calculation because they hadn't attached a spreadsheet, albeit that they had actually been issued the calculation previously. So anyway, the parties ended up in dispute, and the decision, which dealt with issues A and B in that case, and Coulson said, so he basically dismissed S&T's arguments that Grove's Payless notice had failed to specify the amount due. It was said that the question of whether a Payless notice is compliant is a matter of fact and degree. Coulson also clarified that though there has been a hint in previous authorities that the employer's Payless notice might be construed more generously than a contractor's interim application, there should not be a difference in approach. Arguments from S&T were dismissed that pose hypothetical situations that might arise from a finding that a Payless notice could be compliant where a breakdown was not attached. The judge dismissed these fanciful, factful scenarios in concluding that on the facts of this case, the reasonable recipient would have known precisely what sum was being deducted and the basis of its calculation. So there you can see, Coulson is basically saying that the reasonable recipient here should have known, he did know what his basis of calculation was. I mean, if he had been minded to, look at the figure that was in his Payless notice, and even though it hadn't been, even though one of the spreadsheets had not been attached to payment 22, if he'd gone back to check a previous application, he would have seen that the calculation was there. So again, what he's saying is that, we need to move away from these, these fanciful scenarios and trying to, catch the, I suppose, the paying party out on a, on a slight technicality. He's saying that, it comes down to fact and degree, and on the basis, would a reasonable recipient be able to understand the sum that was being deducted, and also the basis of its calculation. Okay, so that's just a word of warning, when you are dealing with Payless Notices, if you can remember that, have a basic calculation, state the amount due, and just ask yourself, would the reasonable recipient understand this payment? If you satisfy those criteria, then, unless it's something very unusual, you will have a valid Payless Notice. Okay, so finally, the final topic we're going to move on to is smash and grab adjudication. The term gets used quite a lot in our industry. So we're going to start off with what is a smash and grab claim. So in essence, a smash and grab claim is made by a contractor who acts on an employer's failure to issue a valid Payless Notice by claiming payment of sums stated in the interim application for payment, with no regard to the employer's assessment of the validity of such claims. Now, where a project has regular interim payments built in, the risk is somewhat lessened by the employer's ability to undo the effects of an unjust claim in the next interim payment. For this reason, contractors have become more likely to pursue a smash and grab claim in respect of the final interim payment, where the employer's opportunity to undo the claim by the final account may take some time. So yeah, smash and grabs, they happen to interim payments and final account, but they had been more prevalent at final account because it was very difficult for an employer to undo the position. I mean, obviously we know that adjudication is binding unless overturned in subsequent proceedings, but generally the position was that you couldn't go back for adjudication. Now, I think it's a good thing for industry that that position is somewhat changed. Again, it's in the case of Grove versus S&T, which also was very important in relation to the Payless Notices that we looked at earlier. So here you can see it's a significant judgment, ruling that the employer was able to challenge the amount due to the contractor as a result of the smash and grab, even if there was no valid payment and/or Payless Notice. Now, in his judgment, Coulson expressed his dissatisfaction with this smash and grab type claims. And he stated that, "I believe my conclusions will strengthen the system because it will reduce the number of smash and grab claims, which in his view have brought adjudication into a certain amount of disrepute." So you can see the logic behind Coulson's thinking here and what he wants to do. The opportunity came up and he's basically not going to let it slide. He wants to be able to, change the perception on smash and grab adjudication, and he sought to do so through his judgment. Okay, so the conclusions reached on this issue will be of most interest to the construction industry and represent a change of approach from previous authorities. Coulson was clear that an employer can commence a second adjudication to seek the true value of the sum due where it had failed to serve an effective payment and/or Payless Notice to the contractor's application. And in doing this, and he gives 6 reasons in his decision as to why this should be done. Okay. Okay, so the first reason was that the early case authority of Henry Boot Construction versus Alstom Combined Cycles noted that it was always open to the court to revise architect certificates, and this was authority for the court's ability to consider the true value of an interim payment application. So historically, the courts had looked at true value positions, and on that basis, Coulson said, well, accordingly, adjudicators should have the same powers, and that is the current position, as adjudicators can open up certificates and establish what the true value is. Okay, the second ground was that there was no limitation on the nature, scope, extent of the dispute which either side can refer to an adjudicator. And as such, there is no limit or restriction on the powers of an adjudicator to decide the issue. So he's saying there's no limitation. Adjudicators are free to decide, they are free to decide the issue, and that's what he's encouraging adjudicators to do. The third point is that a second adjudication to consider the true value would be a different dispute to the validity of a Payless notice as decided in the first adjudication, as it would address questions of valuation. So there's, as such, there's no problem with jurisdiction, because you can see what he's saying is that the second adjudication, the true value adjudication, is a separate, is deciding a separate point, because the first adjudication will have been the smash and grab to confirm that the payment notice or Payless notice had been issued late, and as such, basically those sums are now due. So no issue with jurisdiction. Okay, JCT, the fourth ground was JCT distinguishes between the sum stated as due, which is the amount in the application for payment, and the sum due, which is the correct payment amount, or what we know as the true value. So long as the sum stated as due has been paid by the paying party, the sum due can be adjudicated. But remember, very important point, you have to pay the sum stated as due from the first adjudication in order to adjudicate on the true value. Key point that's commonly misinterpreted, but is very, very important to note. As a matter of equality and fairness, the employer's ability to adjudicate the true value of the application must be balanced with the contractor's ability to do likewise. It would be wrong to prohibit the employer from doing that which the contractor can do. So what he's saying is that in the in the interest of fairness, the employer can adjudicate on the true value as well as the contractor, and there should be no difference between applications made by either party. Makes sense, and it is as a matter of fairness. The final point here is that there is no justification for previous authorities that distinguish the employer's ability to adjudicate where there is a final application as opposed to an interim application. There is no such distinction in the JCT, and there is no difference between payment rights and obligations in respect of interim payments and the final payment. So what he's saying is that it doesn't matter. You can run a true value on an interim payment as well as a final payment, but in reality, it's going to the true value position is a lot more common in relation to the final account, because if it's in relation to an interim payment, then traditionally you can just you can recover sums due under the next payment under the contract. So generally the true value position is traditionally linked with the with final account and final payments. Okay, so the judgment represents a significant change in the TCC's approach. Coulson endeavoured to bring clarity to the influx of potential issues raised by earlier cases on smash and grab style adjudications and distinctions between interim and final account applications. The comments of the judge have the potential to reduce the impact of contractors' claims for payment on the basis of a failure to serve a Payless notice, Payless or payment notice, now that there is authority in support of the employer's ability to quickly bring a second adjudication for the true value of the same application. So that's what he's saying, is that he's basically leveling the playing field, and it may, smash and grabs may not be as appealing to party where they know there's going to be a subsequent adjudication. So parties can be more sensible in how they wish to conclude their respective project. But just the final point here, as I said earlier, the key point is you got to pay the sum stated as due, which is the sum stated as due under the smash and grab adjudication, and then you will basically re-adjudicate to establish the actual sum due, which is treated as the as a true value position. Okay, well look, that's pretty much it for me. So yeah, we looked at lump sum remeasurement type contracts and just general principles around those. We also looked at just touched on the measurement rules as as in our with the introduction of the new rules of measurement. Also looked at payment schedules and the position following Grove versus Balfour Beatty. Before we looked at Payless notices and what are the criteria, just remember that test, would the reasonable recipient understand this calculation? Very important point to bear in mind. And then finally, the true value position in relation to smash and grab adjudications. And that key point is that you know, in order to adjudicate true value, the sum stated as due has to be paid, and you know, and with the objective of the true value being to establish what in fact the actual sum due is. So that's pretty much it for me, guys. I hope you found that of interest and of use, and I'll happily field any questions that you may have. Okay, thank you.
Right, that's great, Conor. Thank you. We've got a question in here asking, what did you mean by builders rates as an alternative to SMM7 or the NRM2?
Or builders rates as an alternative to SMM7. I mean, no, sorry, it wasn't necessarily builders rates. It was more to do with builders quants, because there is a lot of. I mean, I used to work for a contractor, and a lot of projects were tendered through builders quants, as opposed to you know, the hardline SMM or NRM type methods of measurement. I think that's just because again, if you're going in for a lump sum, you know, the quants are going to be at the contractor's risk, and basically they've got to do their own takeoffs to suit, and for those reasons, I don't think that there was you know, I think employers aren't too concerned about, you know, whether they use SMM7 or NRM, because ultimately risk on those quants is going to remain with the contractor anyway. So that was the point there, Julie.
Okay, so quants as in quantities.
Yeah, exactly. Yeah, quantities. Yeah,
just in case anyone's not getting that one.
Yeah, no, I'm imagining I'm talking to a room full of quantity surveyors, so they will.
It's always a dangerous assumption. Right, another question's coming in. Can you please give examples where each NRM can be used specifically?
Oh God, where each NRM can be used specifically. I mean, God, I mean, there's 3 sections in NRM. I mean, and NRM can be adopted to pretty much any project in the same way the SMM7 you know, could. I mean, it can be used for pretty much for most projects, really, NRM, and there are different quirks with it. So look, it can be used in any way. So there's not really any kind of specific. I mean, you either use it on your project or you don't. NRM will, you know, it's generally like in those JCT 2016 versions, you know, the method of measurement is confirmed as the new rules of measurement. If that's the case, then you've got to adopt NRM wholly to your contract. So yeah, look, it's, you know, it just depends on the project, and just go back and check your contract. Check whether the you know, what is the method of measurement defined as in section 1. Just say if you're talking about a JCT contract, if it says new rules of measurement, then you've got to adopt it to everything you do on that project. So yeah, that's as much as I can advice as I can help with there. Okay. Okay.
To confirm, no payment becomes due unless a payment interval is stipulated.
This probably goes back to the payment schedule. So yeah, no payment becomes due unless the payment interval is stipulated. Well, you see, if you're looking at the payment schedule, then no payment will become due. Just say what happened there in Grove versus Balfour Beatty. The payment schedule expired in July 2015. Now the payment for July 2015, you know, went through the normal contract mechanism and was paid, but the payment for August 2015 and all subsequent payments, no payment became due because there was no date, because there was no dates in the contract that provided for, you know, for the payment to be made. Now the payment process in relation to, you know, interim valuation date, due date, final date for payment, that was all confirmed within the contract. But the problem was that relied on the payment schedule, and when the payment schedule didn't run beyond July 2015, then the payments didn't become due. That was what the court decided, and is what we take to be the correct position in law as it now stands.
Okay. Someone else is asking, if a contractor submits a cost for a project under a stage 2 project, will the contractor be entitled to extra money for getting the cost quants wrong? Will this be a variation at the cost of the client?
Yeah, I mean, again, it kind of depends. You know, this is why I guess we try to start off on, you know, with the standard forms of contract. I mean, generally, you know, what we were saying under, say, the standard building contract 2016 with quants, you could potentially have two different scenarios here, because if the contractor, if the employer has got the quantities wrong and the contractor has relied on that, then, you know, under, I think it was clause 213, the contractor will be entitled to a variation for that. But where, you know, just say if the employer gets the quantities wrong, which are then relied on by the contractor in order to price the contractor's design portions, the CDP elements, well, then the risk of that is more than likely going to rest with the contractor. So you can see there's no kind of hard and fast rule. And I mean, I'm only saying that on the basis of the standard form positions, because that position can change again if you have a schedule of amendments. Because if the schedule of amendments says that the contractor takes all risk on all quants, whether they've been prepared by the employer or the contractor, well, then that's what the parties will have agreed, and that's the position that will apply. So, you know, so again, you won't be surprised to hear a solicitor says, you know, you got to check the contract.
Yes, that well-worn phrase.
That old chestnut, yeah.
Okay, someone else is asking, and what in terms of CMs as they work closely to QS?
Not really. I'm not really sure, but what in terms of CMs? I mean, I'm just taking it. The CM means a construction manager. I mean, you know, some construction managers are involved in the, you know, can be involved in the payment process. Look, I mean, I talk about QSs here, but I mean, it applies to anybody who has responsibility for, you know, agreeing schedules of amendments or or issuing payment or payless notices. I mean, you know, it applies to whoever is dealing with those documents. You gotta understand the law in order to administer it properly. Okay.
Okay. Someone else is saying, going back to your point earlier, would you not have thought that the final date for payment under the Construction Act or scheme would have overwritten the lack of payment date in payment schedule? Yeah,
but yeah, that's what I mean. I did mention that earlier. You know, when I was dealing with this, some people assume that because, you know, we're kind of conditioned to think that if there are any deficiencies in the payment process, then the scheme will be implied. You know, that's why the Housing Grants Act are there basically to satisfy those deficiencies. But the courts did not see it that way. The court said that it was, you know, it was effectively a bad bargain that, you know, that Balfour Beatty had made, you know, and they treated the payment schedule separate to the Construction Act and the scheme, and said, you guys, you've basically made a bad deal here, and we're not going to employ statute to recover it. This is what the parties have agreed. They focused their minds on what was going into the payment schedule. Just because Balfour Beatty have made an error here does not mean that statute kicks in to rescue them. So again, you know, that was one of the key points that was discussed in the case, but Coutson was involved in that case as well. And he said, no, that's not how it works. Get your payment schedules right. That's why we're saying, you know, it's a word of warning. If you're signing payment schedules, make sure you allow sufficient runoff time to deal with any inevitable delays. You know, we all know construction contracts. We know that more than likely there's going to be delays involved. So, yeah, make sure you're extending them payment schedules well into the future, or else if there's no date provided in the payment schedule, you could potentially be working but not getting paid. And you know, there's not many worse situations to be in when you're on site. So just a word of warning, be very careful there, okay?
Okay. Someone else is asking, in the event of the payment schedule situation, I have to be careful how I said that there, could you agree an extension to the payment schedule through the EOT application?
Yeah, you could. I mean, you could agree it in, you know, the problem in that case was that the parties, the relationship was strained. They were basically, Grove weren't minded, and they could have easily done so. They could have easily issued an updated payment schedule if that's what they were minded to do. But the problem is you know, these things come under the microscope when the relationship has been strained and the parties, you know, inevitably end up in dispute a lot of the time. So you can agree, like, you could agree it in an email to say, please find attached an updated payment schedule for the project. But you have to be minded to do that, and Grove weren't because of the issues that were ongoing on site. Look, I mean, if you got an extension of time application and you had gone under the, you know, your relevant events and, you know, section 226, yeah, certainly. I mean, as part of the EOT, you could do it that way, you know, by virtue of the fact that the employer has given, say, Grove has given an extension of time to Balfour Beatty, that they're going to update the payment schedule accordingly. Absolutely, you can do that. But the thing about, you know, again, just going back to the facts there, Balfour Beatty were late and Grove didn't agree with the reasons why they were late. So hence why Grove were minded to punish Balfour Beatty, which is exactly what they did. And it was exactly what the courts ended up, the position that the courts ultimately agreed with. So yeah, I know we talked, the payment schedule is probably the most interesting aspect of it because the judgment comes across so harsh, but that is the situation. And I hope we've made it clear that be very careful with your payment schedules going forward. Otherwise,
we're all getting that, Conor.
I hope so. I hope that's landing, because it is very important. And, you know, as I said earlier, like, statute won't be implied to rescue you. You got to get it right at the front end, okay?
Right. Okay. Well, that appears to be the end of the questions for this evening. So thank you to everyone that's attended. Certificates will be issued shortly, and the recording of this will be up tomorrow. As we said earlier, Conor is available on Conor Ahern at silverllp.com should you have anything specific you wish to ask him. In the meantime, thank you, Conor, for your expertise. Thank you, everyone, for attending, and we'll see you all again online soon.
Okay, thank you, Julie. Thank you, everyone.